Now in session.
Before we call the case for hearing for argument, I want to mention a couple of things to the attorneys. Technology has been working well, but if we should have any glitches on anybody's end, we'll just take a pause, and y'all know to make sure Mr. Hivner's aware, and we'll get it cleared up and proceed forward. We haven't had any problem because between Mr. Hivner and the IT people at the AOC, they've done very, very well, and things are going, other than human error on behalf of primarily me, things are going well. Call the first case, Mr. Hivner.
Peter R. Culpepper versus Baker, Donelson, Bearman, Caldwell, and Berkowitz, PC et al.
We're here from the appellate. You need to unmute.
Can you hear me now?
Yes.
Okay, I apologize.
You proceed.
Thank you, Your Honor. Good day, may it please the court. My name is Peter Culpepper, pro se appellant. Respectfully, 4 minutes requested for rebuttal.
That'll be fine.
This case presents a primary question of law. Does a presumption of informed consent hold when an attorney acts directly adverse to his or her client and fails in his or her duty to disclose a concurrent conflict of interest? The facts briefly are these. This is an appeal regarding plaintiff's legal malpractice claim, primarily rooted in a claim for conflict of interest in defendant's representation of both his company, Provectus, and himself. The trial court ruled he waived all conflicts of interest because of an electronically signed engagement letter and was barred in his claim by the statute of limitations under TCA section 28.3.104C, despite not explicitly applying the discovery rule. Defendants represented plaintiff and his company for nearly 13 years. They represented him before the Securities and Exchange Commission twice in 2016 without issue. They authored and filed a legal complaint against his company's bookkeepers dated November 17th that year, also without issue. But they had him terminated the next month on December 27th. He learned they fired him the next day when they terminated the representation of him, having abandoned him in less than 48 hours. However, he did not discover they were the cause and reason for his termination until over 16 months later, May 13th, 2018, when his new attorneys informed him of the viability of a cause of action for legal malpractice against defendants, because they had met secretly in 2016 with a third-party investigator and used that third party's findings as justification for them to falsely and improperly terminate him. The argument is, first, conflicts of interest and informed consent. Second, conflicts of interest and legal malpractice. Third, A, the implication of the discovery rule in malpractice. And third, B, in fraudulent concealment. Finally, application is made to the case here. First, the rules of professional conduct may provide guidance in defining a lawyer's obligation to a client. A conflict of interest without informed consent is not permissible according to the rules when there is a concurrent conflict. Second, it is well settled that a plaintiff in a legal malpractice action has the burden of proving 3 requirements, including, number 2, neglect by the attorney of a reasonable duty. This neglect may be alleged by failure in the attorney's duty to disclose a conflict. Characteristic of claims include allegations of any conflict of interest arising from the representation of concurrent clients. It is the discovery rule that is used to determine if the statute of limitations is a bar to such a cause of action. Third A, under the discovery rule, a cause of action accrues when the plaintiff knows that an injury has been sustained as a result of wrongful or tortious conduct by the defendant. In legal malpractice cases, the discovery rule is composed of 2 distinct elements. Number 1, the plaintiff must suffer legally cognizable damage, an actual injury, as a result of the defendant's wrongful or negligent conduct. And number 2, the plaintiff must have known, or in the exercise of reasonable diligence should have known, that this injury was caused by defendant's wrongful or negligent conduct. An actual injury may occur when a plaintiff is forced to take some action or otherwise suffer some actual inconvenience such as incurring an expense as a result of the defendant's negligent or wrongful act. The knowledge component of the discovery rule may be established by evidence of the actual knowledge of the injury, such as the plaintiff is informed by another attorney of the malpractice. The plaintiff is deemed to have discovered the right of action. Your Honor?
I just coughed.
Oh, I'm sorry. Excuse me, Your Honor. The plaintiff is deemed to have discovered the right of action if he is aware of the facts sufficient to put a reasonable person on notice that he has suffered an injury as a result of wrongful conduct. Third B, the discovery rule does not apply to the 5-year statute of repose under 28.3.104C2, except in cases involving fraudulent concealment by the defendant attorney. A plaintiff must prove 4 essential elements, including number 1, that the defendant took affirmative action to conceal the cause of action or remained silent and failed to disclose material facts despite a duty to do so. The rationale to explain the fraudulent concealment rule is based on the nature of the relationship which creates a duty to disclose. And a breach of that duty constitutes constructive fraud or fraudulent concealment. It's the duty that springs from the confidence and trust reposed by one and another, who by reason of a specific skill, knowledge, training, judgment, or expertise is in a superior position to advise or act on behalf of the party bestowing trust and confidence in her. Once this relationship exists, there's a duty to speak, and mere silence constitutes fraudulent concealment. There are 2 actionable types of concealment, including when there's a duty to disclose, where there is a legal or equitable duty that's required by the party knowing such facts to disclose them. There's not a requirement for the plaintiff to establish the defendant demonstrated an intent to deceive, to establish a claim for fraudulent concealment. Constructive fraud is a breach of a legal or equitable duty, which is deemed fraudulent because of its tendency to deceive others. Neither actual dishonesty of purpose nor intent to deceive is an essential element of constructive fraud. A party commits fraudulent concealment for failing to disclose a known fact or condition where he or she had a duty to disclose and another party reasonably relies upon the resulting misrepresentation, thereby suffering injury, where the plaintiff is not aware of the material fact despite ordinary diligence and would have acted differently if the plaintiff had known of the concealed or suppressed fact. So here is the application of the facts following the argument structure. First, defendant's assertion there was informed consent begs for the presumption against absurdity. There was no oral discussion of any concurrent conflict or otherwise. Any document purportedly provided by defendants as signed is because of trust and confidence by plaintiff and defendants, as with hundreds of documents before and numerous after. There was no independent counsel copied or required by defendants as they had insisted in the past. Plaintiff did not know of any conflict. He was the acting CEO of the company, being considered as permanent, recommended for a bonus the very month he was terminated, and was working as always directly with defendants on a large financing when they fired him. Here, informed consent is a legal fiction. Second, plaintiff has proved that defendants neglected their duty to disclose a conflict of interest because they did so at least twice that is now known, when they met secretly with the so-called independent investigator at least once in August 2016, and also when they terminated him in December. The subsequent revealing of their failure to disclose material facts triggered the discovery rule. Third A, plaintiff suffered actual injury when defendants improperly terminated him. Plaintiff subsequently incurred nearly $1 million in legal expenses until his new attorneys finally learned on May 12, 2018, that it was in fact defendants that caused his actual injury. And then his new attorneys informed him of the malpractice with defendants, who had used the false information they concocted with the investigator to impugn plaintiff to both his company and the SEC not more than 2 weeks after terminating him. Thus, according to the discovery rule, plaintiff's cause of action accrued when he knew of defendant's wrongful conduct. Third B, plaintiff has proved that defendants failed to disclose material facts despite a duty to do so. The relationship of plaintiff, Peter, with defendants John, Tanya, Lori et al. Was not casual or one-off. He worked with them closely for many years. Peter had directly or indirectly paid John's firm millions of dollars over more than 10 years. Peter was working with Lori and Tanya the days before and after Christmas 2016, not more than 1 or 2 days before they terminated him, without a scintilla of evidence. They failed to uphold their duty to disclose material facts they knew he would want to know. And he detrimentally relied on their misrepresentation because he lacked knowledge of their directly adverse actions, which barred his ability to object.
Sir,
Yes.
let me ask you a question.
Yes.
What
yes,
you're
Your Honor.
presenting to us is what the proposed facts would be if this case went to trial. But this case went off on a motion for dismissal, a judgment on the pleading. Is that correct?
Yes, Your Honor.
So then the trial judge only looked at the pleadings and making a decision. This proof that you're presenting to us was never considered by the trial judge. Is that correct or is that wrong?
I do not know, Your Honor. I believe everything that I presented to Your Honors today is in the record, but which was before the trial judge.
Was
That's
that
my
in,
understanding.
was that in the that's in the pleading? What you're
Yes, Your
presenting
Honor.
to us?
Yes, Your Honor. So, thank you. So what the plaintiff was not aware of the suppression of material facts despite good faith, extraordinary efforts by his numerous attorneys. Peter was deceived whether Lori et al. Intended it or not until what they had concealed was revealed. Perhaps unwittingly, defendants have sought to use the history of plaintiff as the CFO as an excuse for their misconduct in firing him after he had been the acting CEO for nearly a year. Defendants appropriated the term recklessness from the arbitrator whose impropriety is under review because each of the 5 investigators who previously worked with defendants for upwards of 10 or more years determined the plaintiff was 100% compliant with his company's expense reporting policies that defendants had put in place, which the SEC also determined the plaintiff complied with. It was not until the 6th investigator who defendants secretly met with could they presumably achieve the wrongful termination of him. And I before yielding to Mr. Blair, everything I have presented and trying to present is in the record, Your Honors. Thank you.
You have your time for rebuttal. We're here from the appellate now.
Thank you, Your Honor. Sam Blair from the Memphis Shelby County Bar. I'm privileged to be the general counsel of Baker Donelson and to represent the defendants in the case. Baker Donelson has represented Prevectus for about 20 years. There was a 2016 SEC investigation, and so Prevectus wanted the firm to not only handle that for the company, but also to represent the officers. Several officers signed the same letter that Mr. Culpepper signed. That engagement letter was made very clear that we could share everything with the company, that all conflicts of interest, past, present, and future, would be waived, and that Mr. Culpepper would agree that we could represent the company if a conflict arose, even if it was adverse to Mr. Culpepper. The end of the letter says, and it's a long letter, but it's well done in my opinion, says, I, Mr. Culpepper, have carefully read the foregoing letter, considered all information necessary and useful in determining whether or not to consent to the representation. I've been encouraged to consult with independent counsel regarding this consent, and I'm fully aware of my legal rights in this regard. Upon reasoned reflection, I hereby voluntarily consent to the representations by Baker Donelson as outlined above. We do take the position he waived all conflicts of interest and that a conflict arose, because what happened was the SEC did an inquiry or an investigation. We represented Prevectus and the officers when they were interviewed with the SEC. They all signed that waiver letter, and Prevectus decided to do their own investigation. Instead of having us, the day-to-day lawyers for Prevectus, they hired independent counsel who hired an independent forensic accountant named Soldinger. Mr. Soldinger interviewed all of the officers and interviewed Baker Donelson. Strangely, plaintiff complains about that interview, but Soldinger was doing his job. He provided plaintiff with an opportunity to respond to his initial draft report, but his final report came out in late December to the board of Prevectus. And that report said that plaintiff had received as CFO hundreds of thousands of dollars in expense reimbursement, $300,000 without receipts or any basis whatsoever. He was asked whether it was a mistake or not, or could it be explained otherwise, and he responded, no, it was systematic and it was intentional, and it got worse every year. Provectus fired plaintiff for cause pursuant to the employment agreement. Baker Donelson terminated its limited scope SEC engagement both in late December 2016. Now, we've been accused of fraudulent concealment and all these other terms. There is no way we covered up anything. We sent out notices to the plaintiff representing Provectus, just like our letter said we could, because the firing for cause by Provectus triggered a bunch of other contract clauses. So that triggered a mediation, that triggered an arbitration. We handled all of those matters. Plaintiff didn't seek to raise a conflict of interest. He knew he'd waived it. So we handled the mediation in 2017. We handled the arbitration in 2017. We even deposed plaintiff in March of 2018. This conflict of interest claim doesn't come about until May of 2019, more than 1 year after his deposition. In his deposition, he complains about virtually everything that's in this complaint in his deposition against the firm. We quote some of that in the brief, but clearly he knew what allegedly his claims were way back then. So what we did was in plain sight, and strangely, he takes the position in his reply brief, page 15, defendant's representation of Provectus against plaintiff prior to May 12, 2018 was not sufficient to raise a conflict of interest with defendants because there was no evidence of defendants acting directly adverse to plaintiff. It's a very strange position because attached to the complaint is the arbitration complaint that we prepared for Provectus and served on Mr. Culpepper. It was very obvious. We were the lawyers for Provectus during all this time for 2.5 years before he filed this lawsuit. So we have 7 claims in this case. Let's talk about the last one first. The 7th claim is unauthorized practice and improper conduct, which is exactly the title 23, Chapter 3. That only applies to people that are not licensed lawyers. Paragraph 2 says we're licensed lawyers in the complaint. We admitted it. There's just no basis for that claim. He also said that he paid us. He didn't pay us. His deposition says every time he would have paid us, apparently with his own credit card, which we didn't know, he was reimbursed every time. He's judicially stopped to make that claim because he under oath testified more than 1 year prior to filing the complaint that he was reimbursed. So when he says he paid us, he actually didn't pay us. So the 6th claim is violation of Tennessee rules professional conduct. The preamble and scope, paragraph 21 says violation of a rule should not give rise to a cause of action against a lawyer. The rules are designed to provide guidance to the lawyers. The rules are not designed to be a basis for civil liability. The purpose of the rules can be subverted when they are invoked by opposing party. That's exactly what's going on here. We have a disengagement letter that's very clear, December 28, 2016, and that terminated the limited scope engagement, and it also provided that we would continue to represent Provectus as our August 2016 engagement letter said. It's in plain sight. There is no fraud. He knows we're representing Provectus against him. So there actually is no claim of a violation of the rule because we had a consent and waiver, and so those documents I'm talking about, the consent and waiver letter, Exhibit 1 to the answer. The disengagement letter, December 2016, is Exhibit number 2. The arbitration complaint is Exhibit number 3. Exhibit number 3, arbitration complaint, has the contracts that are in play between Provectus and the plaintiff. Baker Donelson was not parties to any of those contracts. So when you look at the 5 counts the first 5 counts, every single one of them were litigated or arbitrated, very hotly contested arbitration between Provectus and the plaintiff, and plaintiff lost every one of those issues. The first one, manipulating the board somehow to commit via legal malpractice to breach the employment agreement, the arbitrator ruled, and that's in exhibits 4, 5, and 6 attached to the answer. The arbitrator ruled that Mr. Culpepper breached the employment agreement. Provectus was properly fired him for cause, and so the claim that we somehow induced Provectus to breach the contract doesn't make any sense. Besides, he is collaterally estopped to litigate that again. Number 2, it says that we somehow manipulated Provectus to come up with the wrong number on what the other contracts mean when he was fired for a cause. In other words, how much did he owe? And the question, that question was also hotly arbitrated. The arbitrator ruled against Mr. Culpepper, and the total arbitration award is almost $3 million. So that's collaterally estopped. Number 3 is that we somehow indemnify him for attorney's fees pursuant to these contracts or the bylaws of Provectus. Of course, we're not parties. Defendants were not parties to the Provectus-Culpepper contracts. Only Provectus and Culpepper were. So that one doesn't state a claim. 4 and 5 are defamation, false light, invasion of privacy. He said exactly those words that Baker Donelson caused: defamation, invasion of privacy, and false light in March of 2018, in his March of 2018 deposition. He said it in terms of, it was in the SEC documents that Provectus filed that he said the defendants wrote. Statute of limitation ends that claim because his deposition was more than 1 year prior to filing the complaint. Furthermore, the arbitrator ruled that there was no defamation, there was no invasion of privacy, there was no false light, and therefore on the merits he loses and as a collateral estoppel matter. As far as what Mr. Culpepper said today, those factual allegations are not in the complaint or the amended complaint. In fact, the individual defendants are not in the complaint or the amended complaint. Not once does he mention any of the 6 individual defendants having done anything in the complaint. He uses the word defendants, nothing else. They're not in the they're in the style, and that's it. There were a lot of things he said today that not only are not in the complaints, but they're not in the record. Now, he did attach an answer, or he did file an answer to an answer, which I've never seen one of those. He attaches the arbitration transcript, but that transcript doesn't help him out because exhibits 4, 5, and 6, the arbitrator's rulings to our answer, Mr. Culpepper lost on every one of these issues. So he's collaterally estopped. So statute of limitations has run. He knew we were representing Provectus on and after December 28, 2016. He waited 2.5 years to raise the conflict and sue us. He's collaterally estopped because of the arbitrator's rulings. He's judicially estopped because of his testimony, which is also attached to the answer, and that deposition is number 7 attached to the complaint. The board meeting minutes where Mr. Soldinger provided his final report, that's attached to the answer as Exhibit 9. All of these defenses, or virtually all of them, except for he raised the conflict and he raised the statute of limitations. All the other defenses he hasn't even raised in his complaint. So in essence, he's waived those. There's no sense in talking about his 700 discovery request. He hadn't talked about that this morning. That is his first appellate issue, but obviously if the case is dismissed, discovery is no longer needed. So the trial court was right in all respects. The trial court's order says most of these defenses, but then she also rules, I'm granting the motion on all grounds in the motion for judgment on the pleadings. Mr. Culpepper hadn't challenged most of those grounds. I have a little time left, and I would love to answer any questions that the court would like to ask.
I hear none.
Thank you, Your Honors.
All right. Mr. Culpepper, you have your time for rebuttal.
Thank you, Your Honors. I appreciate Mr. Blair's recitation. I believe there are misapprehensions in various of the facts and the claims. Thankfully, they have been addressed in the brief and the reply brief. I think Judge McClarty's question may be the one that I'm stumped on the most is the pleadings and the naming of the various defendants have all been in the record. So when I say the record, I'm talking about the 1,400 plus pages that are all provided to the appellate court, because all the names of the parties are actually in the arbitration hearing itself. They're in the redacted board minutes, the part that's not redacted. So there's a number of individuals and supporting documentation that was provided as either as an exhibit 1 to the complaint itself, to the SEC, where plaintiff was disputing the action of determination, and then subsequent to Mr. Blair's 24 defenses. In the response of all 24 defenses, there was a denial of all 4 of Mr. Blair's affirmative defenses to the actual complaint. So there's a significant amount of exhibits that are part of not just the original complaint, but then principally the response to the following of the response to Mr. Blair's 24 affirmative defenses. I would like to comment briefly that I think the crux is what Mr. Blair started off with was an engagement letter. There is an engagement letter that was purportedly signed by a plaintiff. The problem with that is there was not an awareness of any concurrent conflict. So when Mr. Blair says that conflict was waived, that's really the crux. And I believe the primary crux of the lower court's decision was the conflicts of interest were waived. They were not waived because there was no acknowledgement that Baker Donelson, and here's a key point, that the certain defendants, which have been named, I don't want to name them on live stream, but certain of the defendants participated in a secret meeting that was not revealed. And this is a crux of it, a secret meeting that was not revealed. And this is in volume 1 of pages 67 through 75. This secret meeting notes came out. So this is the fraudulent concealment that was brought to plaintiff by plaintiff's attorneys. So this was the realization that defendants were in fact working directly with the investigator, and even referred to plaintiff as negligent, never to himself. So if plaintiff had been referred as negligent by defendants, then plaintiff would immediately had a conversation with independent counsel to rectify, because clearly the investigator then said under deposition of the arbitration that 41 to 48% of his report was not accurately prepared because defendants had withheld information. So this is actually part of the record as well. The defendant in the arbitration, this is volume 4 and primarily the arbitrator's reply brief by defendant. As we're coming to a close, I would like to request, for the reasons set forth, appellant respectfully request that this court reverse the ruling of the trial court and remand to the trial court for the determination on the merits of the complaint, whether the claims filed by appellant sound and legal malpractice by the appellee. Thank you, Your Honors.
Thank you, Mr. Culpepper and counsel. We appreciate your arguments and the briefs on this. You may already be aware of the procedure, Mr. Culpepper, but just to make sure you understand fully, we'll take this under advisement and we'll issue a written decision, and we'll send it to you and the opposing counsel here at the same time. So that's how you'll be notified.
Thank you, Your Honor.
Thank you, Your Honors, for having this by Zoom. I know it's a tough time, but this is very good. And I know y'all had to work really hard to do it. Mr. Hibbner did a great job to get us prepared. So thank you very much.
Yes.
I appreciate that. We appreciate the lawyers and Mr. Culpepper here agreeing to do it this way. It is certainly interesting times, isn't it?
Yes, sir.
Great many ways.
Thank you.
Mr. Hibbner, if you would, please recess court until 1 o'clock this afternoon.
This court is